All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. We'll hear arguments in three cases this morning. First is 21-135 in re Rudolph Automotive, a petition for writ of mandamus from El Paso County and the 8th Court of Appeals District. Then 21-941 PNC Mortgage versus Howard from Collin County and the 5th Court of Appeals District. And finally, 21-1063 in re Kappemeyer, a petition for writ of mandamus from Aransas County and the 13th Court of Appeals District. Court has allotted 20 minutes per side in each of the cases and will complete the arguments before lunch. The arguments are being webcast live this morning and will be available later in the court's archives. Justice Lehrman cannot be present this morning but expects to participate in the decisions of all three cases. We're ready to hear argument in 21-135.
May it please the court, Mr. Jefferson will present argument for the relators. Relators have reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court, the plaintiff secured a $4 million verdict after a 3-week trial, but the jury also refused to find that Rudolph Motors was directly liable. More than 4 years ago, the trial court ordered a new trial, adopting verbatim the plaintiff's proposed and flawed grounds. If this order stands, Columbia and Toyota fall. I would like to begin with the plaintiff's oral argument exhibit, which was submitted yesterday. It focuses on Dr. Wimbish's testimony. She argues that because the trial court granted a motion in limine regarding the plaintiff's drinking alcohol prior to the event in question, the trial court properly granted a new trial. Yet, it's important to note that it was the plaintiff's counsel that asked Dr. Wimbish to provide information he had about Villegas's alcohol consumption that was different from what she consumed that night. Now, the trial court remarked that the plaintiff's counsel very widely opened the door on this and invited error. Evidence like this is not incurable if the complaining party invited or provoked it. But any harm was not only curable in this case, but if there was harm, it was cured. The court gave an extraordinary and harsh instruction to the jury. Here's what the court said. You heard testimony from the witness that is not credible, is unreliable, and not evidence in this case. You are instructed to disregard Dr. Wimbish's testimony on all evidence concerning Villegas's prior use of alcohol before this incident. In other words, you can't believe a word he said, is what he was telling the jury about Dr. Wimbish. The trial court then asked each juror individually if they would follow that instruction, and each individually confirmed that they would.
But even that process illustrates that the trial court was somewhat troubled by what happened in connection with that testimony and the reaction that it created. So if the trial court denies the motion for mistrial at that time and then gives the instruction, but evaluates it at the end of the trial and concludes I should have granted the mistrial, does the trial court have any leeway to do that?
So under this court's precedent, maybe. But it depends on what is the evidence that we're talking about and what would make it incurable. What would make it incurable with the instructions the court gave? Now, this court has said incurable is very rare. It almost never happens. It arises with respect to racial prejudice or unsupported charges of perjury or some
But we say
use-
that in connection with a decision which the trial court has determined that in the exercise of his or her discretion, the instruction cured the improperly admitted evidence. So here we have the opposite. The trial court granted the new trial.
But the evidence, the record shows that if there was any error in Dr. Wimbish's testimony, which they invited, again, you have to recall that under this court's precedent, if they invited or provoked it, it's not preserved. But let's assume that they did preserve it, even though they invited it. Here, the record shows that the plaintiff won anyway, prevailed in this jury trial. And again, I go back to whether it's incurable or not. If it is curable, then this instruction did it. If this court holds that it is incurable and this instruction didn't do it, just imagine what is going to happen. Toyota and Columbia will be a dead letter because this will be the template for new trial. For trials to come, this will be like new trial is granted in the interest of justice and fairness, which is what the Toyota court in Columbia said. That's not enough. If this works in a 6-week trial or a 3-month trial, there's always going to be some
Would a
objection.
district judge want to redo a 6-week or a 3-month trial? I always thought the district judges would say, even if there was an error, to send it to the Court of Appeals, Supreme Court, and say, go ahead and reverse it, but please don't make me do a new trial. That's the lore, at least. Why would when a district judge says, I want to redo a 3-week, 6-week, 3-month trial, that seems more of a man bites dog kind of story. Why wouldn't we credit that?
Well,
just for that reason alone?
it's when a court abuses its discretion. And here, the trial court, first of all, gave the plaintiff's charge, gave the plaintiff's instruction, and now gave a new trial based on verbatim arguments that the plaintiff presented to this court. And so there are going to be instances. Flores, way back when, that set the standard for new trial in the interest of justice and fairness. After you saw that, you saw it repeated time and again, where after months or weeks or sometimes even longer of trial, the trial court gets rid of the jury's verdict and makes the court waste its time. The jurors have wasted their time. All the witnesses have wasted their time. Memories fade. This trial was back in 2018, I think. It's almost 2 years at the Court of Appeals, and now we're going to do it all over again. If you read Chief Justice Alley's dissent, I think it gets to the core of why you will, and you've ordered the examination of the excuses like this for new trial.
It would not have been wrong for the judge to have granted the mistrial, or would it have been, if the judge had the colloquy, which Justice Blaine says I read that, he was very, very upset by what had happened, it sounded like to me. Polled the jury, gave that very harsh instruction described, polled the jury, everything happened the same. If at the end of that he had said, I just can't do it, I'm going to have to do a new trial, I'm going to grant a mistrial and we're going to start fresh, would that have been something that was a legal error?
So I think it would have been another abuse of discretion. And one thing that we haven't, that this court hasn't talked about yet, is in that instance, where a mistrial is granted in the middle of trial, must the trial court provide reasons, just as it would in a new trial. But remember, this happened at the end of this 3-week trial. So all of this testimony had taken place. Witnesses have been, up and down. And that's an open question, I think, whether mandamus would have been appropriate for a mistrial granted at that time. The problem with that is, the jury is gone by the time mandamus is decided, so there's probably very little way to correct that error. But here, the trial was over. And the trial court, yes, the trial court was concerned, and I get that, and that is in the record. But the trial court also recognized that it was plaintiff's counsel that opened the door to this testimony. And so the trial court is thinking, are we going to really waste all of these people's time for something that you provoked to come into the record that didn't even impact the verdict?
Couldn't plaintiff's counsel have assumed that the in limine instruction would be followed?
Yes, and should. I mean, you should always expect that and respect the trial court's orders. The new trial here was not based on the violation of a motion in limine. And not every violation of a motion in limine causes error. In fact, you've got to preserve it down the road later. The point that I'm trying to make here is if this is incurable like a racial epithet or allegations of or improper insertion of insurance and that sort of thing, these rare instances, then what you have held about new trials goes away. And I think that's the problem.
If we agree with you and grant you your relief, the relief that you've requested, the trial court will proceed to a final judgment. And is it your position that your client won't challenge that final judgment on appeal based on some other errors that the trial court did not identify?
If we receive the relief that we're requesting here, yes, it'll go back down for the trial court's entry of judgment. If the trial court follows what the jury did and what the evidence shows, the trial court is going to say that this no answer, in fact, the jury basically 3 times said Rudolph Motors is not negligent in question.
Well, a failure to find negligence is not a finding of no negligence.
That's correct. But the jury refused to find that they were negligent.
But wasn't one of the employees submitted and the jury found that that employee was within the course and scope? So will there be vicarious liability for Rudolph?
Yes, there could be.
But you would challenge that if the trial court rendered judgment on that basis against your client?
Well, I don't know that we would. I don't know that we would. I mean, that's something that we would have to consider. But that is another way to look at this. If you look
That's my concern. If the end result is a new trial after final judgment and on appeal, aren't we right back to where we are right now with the trial court ordering the new trial instead of the appellate court?
I'm not sure why there would be a new trial.
Okay.
So you won't be asking for a new trial?
If the court does what I think the court should do, which is to say,
Our court or the trial court?
the trial court. Okay. So if you agree with our proposition that these reasons are invalid, they do not support a new trial, then it goes back down, right, to the trial court. And the trial court is going to need to enter judgment. What is the trial court going to enter judgment on? As we stand today, Rudolph Motors has not been found negligent. The jury answered no with respect to Rudolph Motors twice, and a third time if you consider question 6 that looked at whether they were serving alcohol as a Rudolph Motors function.
Right,
So
but as we discussed, there could be a judgment against you for vicarious liability for the...
Well, there's a judgment against, there's a verdict against Flores, but Flores has been non-suited. Flores is no longer in the case. And there's a percentage far lower than 50% anyway with respect to that. So I'm not here to tell you that there would be an appeal of what we think would be a judgment favorable to Rudolph Motors.
Is the J&OV still live?
So the judge, if the court...
Would it be if we grant you your relief?
I think so, because it would go back down. It would be as if we're back in the status quo. A verdict has been decided by the court, by the jury, and the court is going to have to decide what to do with that verdict. Under 329B, there will be motions for new trial, probably motion for J&OV on both sides. And if the court were to grant a new trial, then we would test the reasons for that new trial under whatever different reasons that the court came up with. But at this point, what we're saying is that these 4 reasons that the court articulated here, they just have no basis in the record. And under Toyota and Columbia, it means that this new trial is wrong and was an abuse of discretion.
But it couldn't be harmless if you think there should be a new trial for a different reason.
No, I mean, and who knows what the trial court would do if there ought to be a new trial for a different reason. But Rudolph Motors, the very first instruction laid out their theory of direct liability against Rudolph Motors. Our contention is this was an after-hours event. This was not sponsored. There was no direct negligence on Rudolph Motors. We argued that with testimony and with the argument, and the jury agreed. And we sustained, 3 weeks, and before that, years of discovery and litigation to get to that point. And that's what Toyota and Columbia are all about. You don't require the parties to go through this intense process and get a jury determination only for it to be set aside on invalid grounds.
You're saying that if we agree with you that the trial court could just come up with a fifth reason, and then we could go back through the whole process if each challenge come up, and we say, no, that's not good either, and then they go back down, and maybe a sixth reason?
Sure, yes.
There's no end to this until the trial court gives up or the parties do?
If the trial court is going to grant a new trial on invalid grounds 10 times, then we'd be back here 10 times. I think at some point, the court would understand that what you have said is that trials mean something. There's a constitutional right to trial by jury in cases like this, and it is not for a trial court to override them based on invalid grounds. Now, if the trial court had a valid ground, I can't see where there would be one in this case. That's a different animal, but that's not the case here.
Trial courts could just hold back. If there's no new development in the case, why would a trial court be able to whip out a new reason after all of these proceedings? I'm having trouble understanding why that would be the case.
I hope the answer would be they can't, but procedurally, I think procedurally, if we prevail with this writ of mandamus, it puts it back to the point after the jury's verdict. And then the parties, they wouldn't be able to make these arguments. I can anticipate they would make other arguments. The trial court shouldn't do it. Maybe it's a stop. You could envision writing an opinion at some point that puts an end to the repeated issuance of invalid new trial orders. I could see that if you see that that's the pattern. But right now, just dealing with what we have in front of us, I think under this court's precedence, those grounds are not valid. And this court should issue a writ to compel the trial court to vacate those grounds.
Any other questions? Thank you, Mr. Jefferson. We'll hear from the real parties.
May it please the court, Ms. Pruger will present argument for the real parties in interest.
May it please the court. To address what you've been asking about, Justice Young, we are here because of the line of cases that this court has come up with since 2009 in Ray Columbia, in Ray United Scaffolding, in Ray Toyota, to present a standard and balance the role of the jury, the role of the trial court judge with that distinct observational vantage point in the trial court, and the review by the Court of Appeals. To maintain that balance, this court, through the trilogy of cases, has developed the proper standard for reasons for a new trial. And you did not hear opposing counsel fully address that standard or what standard should apply here. The standard that should apply is that the reasons are reasonably specific, cogent, that it's a legally sound basis, and that those reasons are matched by what's in the record. When you look particularly at the reason that was discussed during opposing counsel's testimony, the improper injection of testimony by Dr. Wimbish, first, the trial court did not conclude that was invited error. There are some comments during the extensive discussion that displays how disturbed the trial court was about the injection of that testimony. But the trial court does not determine that was invited error. And when you look at the list of questions, it's clear that plaintiff's counsel was asking the witness about alcohol consumed that night. outside of any concerns about a motion in limine. And what he injected was the concept that the plaintiff is an alcoholic, that she certifies that she wakes up in the middle of the night and has to have alcohol to go back to
Well, that is true, but the district judge gave one heck of a curative instruction. I mean, I almost read that and thought that the jury at this point is just going to regard that expert witness as so far outside the pale that everything else he said might be disregarded. It's a pretty powerful response by the district court to the jury, was it not?
It was a powerful instruction to the jury, but as we create this balance, there has to be some discretion and deference provided to the trial court as part of being the observer in the room. Yes,
If we agree with you that the trial court could conclude that the evidence was improperly admitted and the instruction didn't really ameliorate that testimony, here we've got a no liability finding for Rudolph Mazda. So how did that testimony, affect the determination that there was no premises liability, there was no direct liability? In other words, even if we agree with you that that could be a proper basis for a new trial, why would it be the basis for a new trial against Rudolph Mazda, Rudolph Motors, RM, because the jury's finding there of no liability wouldn't be something that would be infected by the potential contributory negligence of the plaintiff.
Here, the injection of the testimony, when you look at the reason given by the trial court judge, it's that it is so improper that it affects the trial and the verdict in terms of the suggestion that here we have a plaintiff that's a hard worker, there's been no contrary testimony, and the idea that suddenly this is her fault. I think a trial judge, particularly there with that vantage point, can having seen, not just given the instruction, seen the reaction of the witnesses to that improper testimony, having also given that instruction, but also seen the reaction of the witnesses to that testimony, it should have the discretion to make those decisions. And I would point, Your Honor, to the dissent of Justice Alley, because I do think this is important. When you look at what Justice Alley is saying, first, he doesn't think it's invited error. He thinks it's improper in terms of its insertion in the courtroom. Where he takes issue is with the instruction. But when you look at the standard that he offers, he looks to Rule 44.1, which is the traditional appellate standard of review. What he's not looking at is considering how this court has always crafted this line of cases in terms of recognizing the difference between the trial court and its basis and how it is allowed to set aside a verdict under Rule 320. This is in Re Columbia. A discussion, or starts there, a comparison of the trial court and what is the trial court's basis for being able to set aside a jury verdict and what is the appellate court's basis. That's Rule 44.1 versus the discretion provided to the trial court, the concept that your trial court doesn't have a cold record in front of it. Instead, what your trial court has, they are there to observe. They have that observational advantage, and they can make decisions about a new trial on their own motion. Whereas an appellate court has to receive the points of error raised by the parties, has a cold record. And so with that distinction between those cases, particularly a cite to that legal standard in the Rules of Appellate Procedure 44.1, is about a judgment. And that the application of that standard, where you're looking at all of the jury evidence and not providing any deference to the trial court and rendering irrelevant the trial court's position at trial to view all that's going on in the case. And particularly, I think Justice Alley's dissent highlights he was not there at the trial. He's seeing the cold record. And he, in his estimation, that instruction given to the jury was enough. But where is the discretion for the trial court who was there and saw what happened at trial to be able to make that determination? How is Justice Alley not simply second-guessing the trial court?
What in the record would support this other than the judge just saying, well, I don't think it's enough? a verdict that actually supports the plaintiff, et cetera, et cetera, et cetera. What in the record could we possibly look to, or is the answer there is nothing, and that's why we have to defer to the district judge?
I would say there is not something direct in terms of a statement from the trial court on the record in that sense. But when you look to, it is supported by the record, because when you look to that lengthy, it's pages and pages of the trial court judge, he says disturbed 3 times. He certainly expressed, as we have included in our oral argument exhibit, that he's concerned, and to your earlier question, Justice Young, he has no interest in, this is the last witness, and he is concerned about granting a mistrial at the very end. We've also included in our oral argument exhibit, because I think it's worth noting when you read through that portion of the record, several pages, to really see how concerned the trial court judge is about this testimony being injected. And it includes a statement that we've provided from defense counsel as part of this back and forth, which suggests, gives your instruction, well, I have it right here, and I understand that, but we've come so far, Your Honor. My apologies, exhibit 2, the very last box. And I understand that, but we've come so far, Your Honor. I think this instruction where it says you've already decided it's not probative, not relevant, disregard Dr. Wimbish's testimony on that issue, and then we leave it alone and get this case to the jury so they can render a verdict. And then obviously, well, we'll, can decide about that afterwards. And when you look at the concern that the trial court had and seriously considered granting that mistrial, that is supported by the record with the idea that the trial court thought the instruction was simply not enough. And that's where it's important for this court, as it is, we maintain all 4 reasons in this new trial order are supported by the standard initially begun in Reg Columbia, given additional scope and explanation in United Scaffolding, and then under certain, you want to check, as is discussed, a merits review, as is discussed in Ray Toyota, but only so far as seeing that is supported by the record and not squarely conflicted. And in all of those cases were not about curtailing the discretion of the trial court. Those cases were about providing transparency and asking the trial court to provide its reasons for why it was granting a new trial, because previously there was no review. And when you're trying to protect that trial court's discretion and the role that the trial court has, but also protect, in that balance, protect the role of the jury.
So in that balance, there's an interesting distinction, it seems to me, between what the trial court's doing at the initial stage, where the question is mistrial or curative instruction, because there's a veil of ignorance there. The court doesn't know what the jury is going to say. And so you might imagine a better argument for pure discretion in that context, as opposed to post-verdict, the court knows what the jury has said, and then there's the risk that the court's analysis of whether the evidence was too prejudicial is influenced by the court's own assessment of the evidence and sort of surprise at what the jury has found, and it bleeds into more of a great weight and preponderance kind of a thinking, rather than, because the veil of ignorance is gone, you know what the jury's done. These seem like different situations, and I wonder whether the discretion ought to be different given what the judge knows at the time the decision's being made.
And just to make sure I understand your question, should that treatment of discretion be different depending on whether there's been a decision before the jury verdict to decide that the evidence was so improper, or a decision after the verdict? Yeah. I think that the discretion standard is the same, because there is still an importance in looking to the trial court judge as not part of the cold record there at the trial and observing there, because the trial court judge may not know until after the jury verdict comes in that the instruction was, he may have a sense based on what he sees in the courtroom, But there may be other aspects, once you've received that verdict, where he confirms his worst fears, his suspicions. And I think the trial court, it's still that same balance. And you look at what In re Columbia, United Scaffolding, In re Toyota have all laid out. You look at the reasons. Has he given a basis? Has he explained what those are? Is it reasonably cogent? It doesn't need to be a pool-like standard where you explain all of your reasons and bases. And I would note for the court, part of the development in United Scaffolding of why you don't require an extensive, detailed list pool-like standard is because, again, of that balance between how you look at the jury, how you look at whether the trial court decides to set aside a verdict or whether the appellate court decides to set aside
If the trial court had denied the motion for a new trial, what would be the result on appeal in connection with the improper admission of the testimony in this case?
I would anticipate it would be an error on appeal, and also an error that would be raised about the propriety of failing to grant the mistrial. And I think you would still be looking at an abuse of discretion standard, but more in the context of a standard appellate review of that abuse of discretion standard, which would differ from the deference that this court should apply here in reviewing, because this is a mandamus review of a motion for new trial in terms of an abuse of discretion standard and how we look at what has gone on at the trial, guided by Columbia, United Scaffolding, and In re Toyota, should be focused on acknowledging that the trial court has not a cold record, but has been a part of the proceedings and has seen the reactions of witnesses and been a part of the trial.
So I have a question about something I think you said earlier, which was that the trial court did not find that the error had been invited. I had a note that the record, the trial judge in fact said, so you invite the error and then you want a mistrial. Is that something that was misattributed to the trial court, or did the trial court later make a different finding?
The trial court did ask a question of nature, and I believe that is a statement in the record. But the idea that the trial court, in fact, found later, if you look in terms of the record and the back and forth, the trial court judge seems to step away from that concept. And again, I would note, even in Justice Alley's dissent, he doesn't find that is invited error. And I think when this court looks at the record and at the questions, her questions were about alcohol consumed that night. That is consistent with what was a part of the motion in limine. And the answer that is given is based on a statement from a deposition that was never part of the testimony at trial, a statement from the deposition of a witness who said something akin to, somebody told me that Ms. Villegas said she drinks alcohol at night to fall asleep. And as is evident from the record, the trial court judge was extremely disturbed by that and its injection at that late hour, the last witness of the day, and a witness that is a forensic toxicologist, a witness who, based on the CV that was admitted, as well as statements to the jury, says that his, part of his work involves working with organizations that work with alcoholics. And he's already, this is on cross-examination that this response is elicited, and he has already explained in great detail about alcohol and number of drinks and his expertise in determining people's blood alcohol percentage, as well as looking at their drinking habits.
Back to Justice Blacklock's question, could one valid reason for the trial court to wait to make a decision on a new trial until after the verdict, after having given the curative instruction, be that it could turn out to be harmless if the jury didn't put any liability on Ms. Villegas? It seems like that would be where the harm would normally manifest. If the jury was disregarding the instruction not to consider that testimony, then the jury might think, well, we should put more responsibility on Ms. Villegas for some reason. And if it turned out they had put 0 on her, then maybe that's some indication to the trial court that there wasn't such an effect. Of course, that's not what happened here, but could that be a reason why the trial court might want to wait until after the verdict comes in order to make this call?
I believe so, and I believe the record reflects that when you really see the struggle that the trial court has in trying to decide about this mistrial. It's pages of trying to decide about this mistrial, and again, this is the cold record. None of us were there at the trial, but also you don't, having read the record, you don't see that same difficulty or concern on the record over other decisions. And so, yes, I think that certainly the trial court gave that instruction, hoping it solved the problem, but then concluded after the verdict came in that it didn't.
So in the abstract, aside from this particular issue, but if a conscientious trial judge says after a long trial, a verdict, I have to have a new trial, presumably that trial judge has reasons, we require them to be expressed. If it turns out that they're wrong, would not that conscientious trial judge be happy to learn, no, the trial was okay. I don't have to reinvest 3 weeks plus all of these other proceedings in doing this. It was okay. That's good news, is it not, for the trial judge?
When you say, and again, to make sure I understand, when you say that the trial court finds out the reasons are wrong, it related to Justice Busby's question, I guess, because when the trial court has to list its reasons.
Yeah, I'm just speaking just purely in the abstract, not even necessarily about this particular case, but just in general, a trial judge says, here's why I think a new trial is required. So now I'm prepared because I'm a diligent judge. I'm going to go ahead and invest 3 weeks, 6 months, whatever it is, into the trial. Court of Appeals, Supreme Court sees what the reasons are and can say, no, that reason is not a correct reason to think that your trial was so infected with error that you must redo it. Is that not good news for the average district judge, county court at law judge, to hear, okay, great, I thought I had to do it. I was making my best judgment that I needed to do a new trial. Thank goodness. Would that not be cause for opening the bottle of champagne as opposed to being sad?
Right. No, I now better understand your question. Yes. I think, especially in this record as well, there is not a situation where trial courts are excited, looking forward to, especially when they've lived through the trial. And again, you see this in the court's cases talking about why the power, the broad discretion is a part of what the trial court has to grant a new trial, because they are not sitting there looking for reasons to order a new trial. They provide those reasons. This trial judge provided those reasons, and contrary to what opposing counsel has stated, they do in fact meet the very clear standards in...
But one of those standards should be if they're wrong, then it wouldn't, so that's not cool, that's just,
correct.
Is it an error?
Exactly
so
correct.
You've got 4 reasons that the whole, we've now been 15 minutes or so into it, it's all been about one of them.
Yes.
The other 3 are not, as I understand it, going to be affected by the same question of cold record, what was the demeanor, they're more legal questions. Did Painter affect this? Can we reallocate the the liability? Were the non-economic damages potentially overlapping such that we can say, no, that's the kind of thing that's just not a good reason for a new trial. We can solve that as a legal matter. Do you basically agree that it's the Wimbish testimony that provides the key focus? Is that why we've spent now 35 minutes?
I think the Wimbish testimony provides the key focus, and I agree with your point. And also the Wimbish testimony is a most clear example of why the standard of what's in place in these cases, Columbia, United Scaffolding, Toyota, to your point that if it's simply wrong, that was the situation with Toyota. It was a square conflict. It wasn't the defendant that opened the door for limine, it was the plaintiff. End of story. But that is, this case provides the most clear example of a standard, whereas the others can be addressed on.
Does it reduce to the Wimbish testimony whether or not we think, as a matter of law, that given the curative instruction, given the verdict that supported the plaintiff, et cetera, that was an abuse of discretion, would be an abuse of discretion to order a new trial? Can we basically set aside the other 3 grounds and focus on that or not?
I think you can, particularly because the order talks about these reasons being collective, or they can be looked at collectively or individually. I would also note that the part of what's also addressed in the Dr. Wimbish testimony, in addition to suggestion about the jury being incorrect related to liability, is that the damages are too low. And so there is standing alone, the Wimbish testimony would be a basis to deny the mandamus and maintain the grant of a new trial, but because of the way the order's worded.
Any other questions? Thank you, Ms. Berger. Mr. Jefferson, you have 5 minutes.
This court is either individually presided over or, as appellate judges read, probably thousands of records combined. And in those jury trials, you will see time and again, objection sustained, the jury is invited to disregard. I mean, this happens all the time in just about every trial. If this instance here, where not only did the trial court say the objection essentially is sustained, but then read an instruction to the jury that called him unreliable, not credible, you can't believe a word he says. If that is not enough to cure any error, then, as I said, the idea in Columbia and scaffolding and Toyota goes away. This is the template now for a new trial that overrides a jury's decision. Justice Bland?
Does the other side of that coin, if we're not going to uphold a trial judge's policing of improper testimony, say to any lawyer, go ahead and put it in, because at worst you'll get an instruction to disregard the evidence, and they won't really be able to do anything about it on appeal or with the trial judge to declare a new trial.
So I don't think so, because the instances in which an instruction won't cure are rare. This court has said that an instruction cures the error, and this court has said jurors are presumed to follow the court's instructions. And here, that's exactly what they did.
But because of that, are you just saying that a request for a mistrial just simply isn't a remedy anymore for most improperly admitted testimony?
I think that most judges are going to do the right thing if the testimony is improper. But the court is also going to decide, is the admission of that testimony, did it cause, and this is the standard, the rendition of an improper verdict or judgment? And here, there's no evidence that it did. In fact, the evidence is contrary. What they're saying is the evidence is so devastating that it was going to gut the plaintiff's case. But what happens is the jury found for the plaintiff to the extent of $4 million and awarded damages in every category. And so this was not prejudicial to the verdict,
not damages
judgment.
for disfigurement or.
Well, we can discuss those. There's
no, but there were some damages that were not awarded.
Yes, but this was this is a plaintiff's win. The plaintiffs prevailed here. So whatever testimony came in this 3-week trial did not gut their case, which is kind of the picture that they're trying to paint here. And the instruction did, if it was error, the instruction did cure it, and it was an instruction that is over the top. You know, I mean, in some ways you could say this, you know, if a judgment is against the defendant, there's an argument that this instruction went too far in calling this witness completely unreliable.
If the testimony happened in a trucking accident case and the testimony came in that the truck driver drank himself to sleep every night, same result to obtain?
So if an instruction like this one is given, it cures that. Yes, the same, because this is not an appeal to race. It is not calling somebody a perjurer. It does not.
You don't even need an objection for those sorts.
Right. Well, this is what they're saying here.
Well, this was objected to.
Yes, but they're saying here that you didn't need an objection and that the instruction could not have cured that admission. And I'm just saying, think about the overall picture. Think about the thousands of trials that we have all the time, and evidence does come in, and sometimes mistakenly, and the trial court says, jurors, you will disregard, and maybe pull the jurors and make sure that that's true. We presume the jury is going to follow that instruction. Here, the evidence shows the jury did follow that instruction. The jury found for the plaintiff.
How do we know they followed the instruction when they put 30% on Ms. Villegas?
The presumption that this court has adhered to.
Well, I realize it's the presumption, but you said the verdict shows that they followed the instruction, and I'm wondering how it does that.
Because the jury found for the plaintiff to the extent of $4 million. And they don't complain, they don't say that finding of 30% was against the great weight and preponderance of the evidence. The evidence here is that the plaintiff walked into the path herself of Mr. Ruiz. That is negligence in itself. So it is explainable on that, and no ground in this motion for new trial says, oh, this finding was against the great weight and preponderance of the evidence. There's evidence to support that. So the jury's finding is rational. It's based on the record, and each one of the arguments for granting new trial is flawed and under Toyota, and that precedent the writ should issue.
Any other questions? Thank you, Mr. Jefferson. The case is submitted, and the court will take a brief recess. Please be seated. We'll hear argument in 21-941 PNC Mortgage versus Howard.
May it please the court, Mr. Lemke will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court, just last year, when this case was previously before this court held unambiguously that when a refinance lender's foreclosure claim based on the refinance lien is time barred, that does not preclude the assertion of an equitable subrogation claim. In other words, the refinance lender, time barred on the foreclosure claim, can still resort to equitable subrogation. The court then sent the case back to the 5th District Court of Appeals to determine what is the accrual point for the statute of limitations on an equitable subrogation claim. And the Dallas Court of Appeals held that the accrual point for the equitable subrogation claim is the same as the accrual point for the foreclosure claim based on the refinance lien. That is, it is the maturity date of the refinance loan.
Or when it's accelerated.
That would be an accelerated maturity.
Which moves up the maturity date.
Yes, that's correct,
And
Justice.
the Fifth Circuit has now said that as well in Lamel, so why is that wrong?
Well, the Fifth Circuit in Lamel essentially said this court was going to take it up, and they changed Lamel from a published to an unpublished opinion, and on remand, that district court case it's on hold. It stayed pending this court's decision.
Right, but even in the second Fifth Circuit decision, they say basically the same thing, that the accrual date is when the acceleration happens.
It is wrong, Justice Busby, for multiple reasons based on foundational principles of equitable subrogation doctrine as espoused by this court. First and foremost, it's the LaSalle case. And what LaSalle said was that the equitable subrogation claim does not derive from its contractually refinanced debt and accompanying lien. Well, that seems to be in direct contravention of what the 5th District Court of Appeals said, where they're saying the statute of limitations accrual point is derived from the refinance debt.
Well, but I guess the question is, I mean, if you're standing in the shoes of the original lender, which I take it to be is what happens with equitable subrogation, how do you know when you say I'm accelerating the obligation here, how do you know if what you're accelerating is the new note or the old note?
Well, I think there's only one note for purposes of this doctrine. This discussion that we're saying that there are still two notes, that's not correct. But I do think...
Well, then how would you know what the original maturity date was? Why would you look at the original note?
Well, because that goes to the Zepeda decision by this court, and which is the latest in a long line of cases, saying that the refinance lender steps into the shoes of the original lender and has the same rights, no more or no less.
Right. I understand all that, but did you accelerate the underlying note in this case and make it due? The original note?
The original note, the acceleration notice, to my recollection, does not reference an underlying note. But I think
so you don't have a claim for foreclosure then on equitable subrogation because you've never accelerated the original obligation?
Well, I don't think you accelerate the original obligation. The question, I think you have to look to the original note and see, is it
in the record? Can we look to the original note?
The original note is not in the record, but as we point out, the issue of whether it's barred by the statute of limitations is an affirmative defense, and so the burden would have been on the Howards to put the original note in the record in support of their claim of a statute of limitations bar.
Well, they say you're suing us for foreclosure and you've accelerated, that makes it mature. And so your response to that is?
Well, what they're saying it is mature, and what we say is that even if it was accelerated, the Dallas Court of Appeals failed to take account of the fact that based on their holding, the statute of limitations would run on the equitable subrogation claim before it could ever have been asserted, which that can't be right.
Well, the amicus brief from the TPTLA says that's exactly right, and it puts the responsibility where it belongs, which is on you, to, basically that way everything's within your control. You can assert your claim timely or not, but their position is if we go with the rule that you suggest, that there are going to be traps for the unwary out there, and some refinancing lenders are going to get stuck with no remedy. What's your response to their brief?
My response to their brief, first of all, is that they're wanting to really cast aside the fundamental principles of equitable subrogation and suggest that they get a lien for the length of their loan as opposed to how much the original lender had left on his lien. But as to the point about the trap for the unwary, I think a lot of their argument is really a backdoor attack on this court's ruling in Howard 2, where this court has already said the fact that you did not timely assert your refinance claim based on or the foreclosure claim based on the refinance lien, that does not preclude you from asserting equitable subrogation. So I think they're really attacking that ruling that this court said equitable subrogation is still available when there is a time bar due to the fault of the refinance lender. And I think the answer is, if there is an equitable subrogation claim separate from the refinance lien foreclosure claim, as this court held in Howard 2, how can it possibly be the case that the claim for equitable subrogation is barred before you could ever assert it? Because the law is clear from LaSalle up until the ruling in Howard 2 that you only have an equitable subrogation claim when the refinance lien is infirm. And in the case of
how could it be the case that claim has still not accrued? Your claim, I don't understand. It seems like it's got to be one way or the other, right? You've either got to, if you make a request for an acceleration on the refinance note, that's either also got to be considered a request for acceleration on the original obligation to which you're equitably subrogated, or it's not, and you have to make a separate request for acceleration on the original obligation, which you didn't do, so it's not mature, and you have no grounds to foreclose.
Well, I think the issue is, does the original loan even have an acceleration clause in it? That's what
we don't know, because it's not in the record.
We don't know, but the basis.
But then your foreclosure claim fails.
Well, let me go back to the question you asked a second ago about how could you not have the clock running. This court held in LaSalle, you don't have the equitable subrogation claim until there's no adequate remedy at law. There is an adequate remedy at law with regard to the statute of limitations, up to the point that the statute of limitations bars the refinance lien foreclosure claim. It is then and only then that you could ever assert the equitable subrogation claim. And so
rather than fixing an accrual date as of the date of the maturity of the underlying loan, would it be the accrual date is the date that the predominant loan is declared invalid?
I think for purposes of the equitable subrogation doctrine writ large, which often includes constitutional defects that are where the infirmity is obvious from the get-go and there's no interim period where there is an adequate remedy at law, the accrual point then makes sense that it's the maturity date of the original loan. But to your point, in the statute of limitations context, I think whether you call it, I think there's a tolling concept that has to come into play, that there's no way that you can have the statute of limitations running on the equitable subrogation claim before you could assert it. Because as a result of the 5th District Court of Appeals ruling, you could, even though this court said you can resort to equitable subrogation to overcome the statute of limitations, you never could. So I think you have to say in the context of the statute of limitations that there is an equitable tolling concept that you're not going to have it. So effectively, yes, I think the result will be, with regard to a statute of limitations bar, it's at the moment the legal claim becomes barred, that's when the 4-year statute of limitations would start to run.
Did you ask for equitable tolling in the trial court?
We stated throughout that the adequate remedy at law was was a requirement before the claim could be asserted. I'm not sure we used the term tolling, but we talked about the equitable doctrines associated with the absence of the ability to assert the claim until there's an adequate remedy at law.
And that would be your burden if this is equitable tolling.
Yes, I mean, we would have to, if they presented evidence, first of all, we say they never met their burden on the statute of limitations defense because they never referred to the maturity date of the original loan. But I think if we were, I'm not sure it's even a burden question because it really is just the question of when it starts to run. That's almost as a matter of law that it can't be running until you can assert the claim.
Is a bundle of rights that you're equitably subrogated to track to the lien or to the terms and condition, every term and condition of the original loan? I think the Howard side says it's the lien and the enforcement of the lien that equitable subrogation grants, but not necessarily every term and condition of the underlying loan. Not the maturity date, not an arbitration clause if it was included in there, not other various terms and conditions, but just the lien and the amount due and owing on that lien.
I think this court has drawn a distinction between a procedural issue. In Crowder, the court said, well, the procedures for foreclosure that come up under the new foreclosure docket, the new refinance deed of trust, that controls. But in terms of the fundamental issue of could the original lender have asserted the lien, I think that is the Zepeda idea of you step into the shoes of the original lender. And so if the original lender, for example, if it was a 30-year loan and they're 29 years into it, the original lender only had 1 year left to assert the lien. It would be a massive expansion of the rights if the refinance lender could then, if it was a 30-year refinance, have a 30-year resort to that equitable subrogation lien. And so I think it's the fundamental point of it's mid-continent, this court's decision mid-continent, and then again in Zepeda, that you get the same rights, no more and no less. Now on the procedural stuff like arbitration and venue, this court has said on that, for the foreclosure proceedings, the refinance deed of trust controls.
But let's say that equitable subrogation didn't exist as a judicial doctrine. Could you accomplish the same thing by contract in the refinancing documents?
Well, there are often contractual subrogation clauses that exist, but I'm not sure the concept of the equitable tolling would come into play in that. But the contractual subrogation issue is not really presented.
I understand. Just imagine a world where there's no such thing as equitable subrogation, but you want those same rights. Could you contract for them?
Yeah, absolutely. There are often contractual subrogation clauses.
So what is, and this is just backing up to first principles, what is equitable about the court giving you rights that you have not contracted for?
Well, I mean, this goes back to the 1880s and the fact that Texas has always taken the most robust view of equity.
But I get the precedent, and my question goes to the prior question of why is equitable subrogation equitable when you could contract for it, you could bargain for it, you haven't. Why does the court bail you out?
Well, because it's our reserve parachute analogy that the idea is in order to encourage a robust refinancing market, you need to provide this additional protection because of potential flaws. And in order, it's not only a pro-lender doctrine, it's a maybe not pro-defaulting borrower, but...
So why is the question of whether the refinancing market ought to be promoted a judicial question, a question of equity that a court ought to be concerned with as opposed to a pure policy question? I can imagine all kinds of reasons why you might not want a robust refinancing market. It doesn't seem like the court's got any business basing a doctrine on the presumption that we should promote lower interest rates in refinancing.
Well, certainly no one is urging the overruling of the last 140 years of precedent. Right. But I think, Justice Blacklock, what I would say to that is there's this idea that the law has imported that the refinance lender is involuntarily paying off the prior loan. And because of that involuntary.
Which is a total fiction, right?
It is a legal
There's nothing
fiction, but it's,
involuntary about any of this.
I mean, it is not only in Texas, I think that extends across the country, but the notion of equity is if you're involuntarily paying off a debt that you didn't have to pay off, then it's equitable for you to be able to step into the shoes of the original lender.
And that makes sense as an equitable matter, but the involuntariness piece of it is why it makes sense. And there's nothing involuntary about your engagement with a debtor, and the debtor has paid off the original loan. I mean, it's the debtor that borrows from you and then pays off the original lender. You don't pay the original lender, right? The debtor pays off their debt. And I just cannot understand, just as a matter of first principles, why there's anything equitable about that debt that the debtor has paid off continuing to follow the debtor.
I see my time has expired. May I respond?
Yes, you may answer.
Justice Blacklock, I guess I would say that we're not writing on a clean slate here. And I think that there are certainly reliance interests in this doctrine, and the court has seemed to have recognized for over 100 years that it's important to maintain the availability of equitable subrogation, because it is not only pro-lender, it is pro-borrower, because borrowers who are in trouble need to have resort to the refinance market, and this doctrine makes it more available. But I think that is a bridge that the court crossed decades ago.
Any other questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Ms. Penderi will present argument for the respondents.
Mr. Chief Justice, and may it please the court, I agree that the court needs to clarify something that is important to the jurisprudence of the state, as PNC's interpretation of the line of the federal district cases and the earlier Amarillo case illustrates that has not been understood. Now, I will discuss in a minute why that particular sentence that PNC likes in those cases definitely means something and applies in those cases in a minute. But let me just say what this court needs to clarify is that the payoff of the note changes its maturity date from a future date to the present, just like acceleration of a note does. And there's several Court of Appeals cases saying acceleration changes from a future date to a present date. Now, I will admit that when I first got involved in this case after the remand, I immediately thought, well, excuse me, why doesn't paying off the note mature it? And I couldn't find a case that said exactly that, which is kind of what apparently we need, because when I went to a friend who's an expert in real estate liens, he said, well, okay, that's because maturity date is a very specific technical term that is defined in the note. And for example, this PNC's note says April 1, 2035 is the maturity date of this note. So he said it's not correct to say the payoff date is the maturity date, but it's correct to say there can be no payoff date later, no maturity date later than the payoff date. And so that's what we put in our brief. Now, I will tell you that I tried again to find that kind of case. And when I didn't recently, I talked to the same expert, and he said, well, there probably isn't such a case simply because lenders know that they're not subrogated to the note, they're just subrogated to the lien. So, it's interesting, PNC accuses us of blurring the lines between notes and liens, but that's what they're doing.
What do you, if we don't agree that the payoff date ought to be the accrual date for an equitable claim that arises upon the default of the borrower and the inability to enforce the lien, what do you contend could be an alternative accrual date to that, short of the maturity date of the underlying note?
Well, I agree that the maturity date of the underlying note is it. It's the one that makes the most sense if you don't call that the maturity date. But let me explain what those other cases have found and why that context is there. And it's because those other cases are ones that weren't payoff of loans. They were cases in which the first loan was still active, a home equity loan in 2 of them, a loan where a husband took out a note on the property without his wife knowing about it, but it was a second note, so the first note was still being paid. But let me say, I mean, this kind of goes to their point about it being meaningless for this to have court to have said you can still go back and if you screwed up on the statute of limitations, it would be meaningless. Well, not true, actually. Now, first off, when this court changes the law after the Court of Appeals ruled based on the prior law and didn't therefore get to other issues, this court generally sends it back to the Court of Appeals. But PNC is also not remembering that this court remanded for 2 things. One, to see if there was something that had to do with the statute of limitations that would apply, and I had already thought about asking for equitable tolling, which they didn't do. But this court remanded also for the Court of Appeals to look at our issue that the language of the PNC deed of trust actually precluded its use of equitable subrogation. That's the big thing on the remand. But when we got back and I got involved in the case, we decided that the implications from this court's other language rendered our argument invalid and therefore essentially dropped that argument. But
just looking at the assertion of equitable claims in other contexts, like a breach of contract for services, and the alternative relief that might be available should the contract be found to be infirm, quantum merit. What is the accrual date for a quantum merit claim that's connected to a breach of contract claim?
It's the same. It's the same. Now, all right, again, they're trying to latch on to a First Franklin note that they paid off, not purchased, to help them with this claim and for future cases to give them a holding that parrots that sentence in those cases that gives them pretty much a wide open period of time to use this fallback. And now equitable subrogation does not mean to give them this broad of a fallback, I think, but it just gives them the right to essentially use the language in that deed of trust. And it was their burden when they come to the court asking for judicial foreclosure, it's their burden to put on the documents that establish their right to equitable subrogation. In fact, that note not being in the record kind of doesn't even tell us something like, guess what, if it was a balloon note or a very short-term note or whatever. There were certainly circumstances where it would not help them at all. So, PNC can't not have it better than the lender whose shoes it stepped into. We agree they stepped into First Franklin's shoes, but if they stepped into Ked's sneakers, they don't get to walk away with Air Jordans. It just does not make sense. And of course, I guess they're just asking you by that to assume, oh, that was a 30-year note, so we get till 2033 before our cause of action even accrues and we have to bring it. So,
and maybe you can help me understand, but if they get that and there hasn't, under their theory, there hasn't been an acceleration of the underlying, and I understand your theory about payoff, but setting that to the side for a moment, if there hasn't been an acceleration of the underlying note so as to make it mature, then how could they sue for foreclosure of the equitable lien?
I'm not sure I understand your question.
I don't
actually.
understand either, so I'm trying to see if
Okay.
you can help me understand.
Okay.
Because it seems like they're saying there are two different liens here, and they can each accrue at different times. And so put aside the refinancing lien, because that's time barred, or at least that's not before us. But if they're suing on the original lien and they want to foreclose, it seems like they have to show the note is mature and it hasn't been paid, right? So they would have had to accept, presumably, if the maturity date of that loan is sometime way out in the future, you've got to accelerate that underlying debt in order to be able to foreclose on the equitable lien, if they're really two separate things.
Right, in which they don't have the right to foreclose on that note. Their name isn't even on it. The equitable subrogation only gives them the right to use the language in that original deed of trust.
Which we don't have.
We don't have, but it also, that makes sense in terms of why those cases say it goes by the maturity date, because they are looking at cases that are still active notes. This is the second lien, but also they're looking at things where, that second deed of trust had an unconstitutional provision the legislature changed. In one of those others, only 3 of the 4 people who signed the original deed of trust signed the second deed of trust. So, there's a big infirmity. So that kind of thing is the whole reason for the equitable subrogation.
But it does seem like if it doesn't accrue until the maturity date, then how can you sue to foreclose an equitable lien that hasn't accrued yet unless you accelerate it?
But you're speaking as if the equitable subrogation claim, and it's not a claim, it is
an equitable remedy.
An equitable remedy, right, that it accrues or that it attaches to the original note.
And I understand. I'm just taking them at their theory. I'm not saying I agree with that, but that's their theory, at least that far. So
right.
I'm just trying to understand how that gets them anywhere, because it seems like then you couldn't foreclose because it hasn't been accelerated.
Well, correct, but and you don't have a right to do anything with regard to their note. You didn't buy their note. You refinanced their note. So you don't have anything to do with the specifics of that note, nor would they have the ability to accelerate that note. Now, the seriously bad ramifications of the ruling PNC 6, I will leave to our brief and to the very helpful brief of the TPTLA. I think it is, and it explains why this would be an awful result. But
would you like to address the other issue that might affect this question, which is whether or not there was abandonment of the acceleration?
Well, actually, I don't think I have the name of the case, but it's interesting because there is a case that says the statute of limitations accrual date would be the same under the equitable subrogation and the PNC's note, absent evidence of abandonment of acceleration of PNC's note. They didn't prove that at trial. They did not prove that at trial. And here's what they want. They want you to give them a do-over on the whole trial so they can go back and find the original note, and so they can argue that they abandoned acceleration, when in fact, actually, looking at the facts, they sent another acceleration notice in 2010 after the 2009 one, which they say then they abandoned, et cetera. So, but I don't think they're entitled to a do-over here. They potentially had help from an equitable subrogation, but I don't think that they should be given a do-over. Now, of course, we're asking this court to affirm the Court of Appeals opinion, clarify things a lot more about the maturity becoming the payoff date when it's paid off. And the Court of Appeals had not They just basically said, oh, we agree there's a conflict between these cases PNC raised and us, but we like the way the old Hayes Supreme Court and Kone decided. Well, again, that's failing to recognize that actually there's not a conflict, because those cases were not about paying off liens. They were about secondary liens. So anyway, that was just something that wasn't in there. So let me mention one other thing, that PNC argues that it would make no sense if the statute of limitations accrued at the same time. And as I've mentioned, there's a case that says that's true absent acceleration. No. But also, granted, this is an equitable question, it's a common law question, but this court could be informed by Civil Practice and Remedies Code section 16.035E, which is right under the 4-year statute of limitations for foreclosure. It says if the case is based, or the foreclosure is based on a series of liens, the date of the last one controls when the limitations accrues. Now that may sound like, oh wait, doesn't that automatically just slap them down? It actually doesn't automatically, because that statute refers to a series of liens. This is not a series of notes, sorry. That would be, bank loans me $100,000. Next year it loans me another $20,000. Next year it loans me another $10,000. That's a series of notes. Anyway, but still, it is a good policy reason to have said it can often be the same. Let me just also clarify what happens if this court does affirm. It still ends up in a remand, not a remand for a new trial. In the trial court, that court heard all the evidence, heard everything, had already decided that the foreclosure by the wrong lender who didn't own the note, which forced our people, suddenly their house had been foreclosed on by somebody they had no obligation to, forced them to file for a declaratory judgment that was void. And the court, trial court, had already ruled, yeah, that one was void. And so then PNC sues on the note, and for foreclosure, and all that gets swept in together. So anyway, when we go to the Court of Appeals, it says the trial court was right on limitations expiring on equitable subro. It says the trial court was right in not allowing equitable subro, which is what this court later said no. But the Court of Appeals also said trial court was wrong in not giving PNC a judgment on the note, because that's a 6-year statute of limitations. So it remanded for calculation of the note, which we don't deny. It's now over $1.5 million, because this has dragged on since 2010 with like 3 years of PNC doing nothing and whatever. But anyway, so yes, the court would need to remand just for calculation of that note, which apparently PNC wants both that judgment and the house. So anyway, that's a whole other issue. But so we're asking you to affirm the Court of Appeals decision, but just explain a couple of things in there, and explain how, of course, actually the payoff date is the maturity date, but also explain how the cases that PNC likes, because they have that good sentence for future use, don't really apply anyway. That sentence was fine for those cases. It doesn't apply to this payoff case.
Let me ask you this. It seems like we've got 3 potential dates now at least. You've got the payoff date, you've got the maturity date, and then you've got the date of acceleration, which I guess would be what the Civil Practice and Remedies Code section you referenced says you go by the last note, and so when they accelerated the last note, that would be the date. And you would be okay with that as well, I take it, because that would also mean that the equitable subrogation claim would be time barred, either under that or under the payoff date.
Correct. Well, and yeah, and none of those other dates would help them. Yes, there's a
Except the
potential for
maturity
3
date.
dates, but I agree, it's 4 years from the maturity of, or from the acceleration date.
Right.
And that's what they blew. And we gave them notice of that by filing our lawsuit 3.5 years, I think it is, before they actually made that claim. So I don't think this is the kind of equitable relief that the common law theory encourages.
So, but to be clear, under your approach, the concept of equitable subrogation would provide no value to a refinancer if the reason the refinancer is unable to foreclose on its own loan is a limitations problem. If limitations is what prevents them from collecting on their refinance loan, then there's no scenario in which equitable subrogation to the original lien would have any value to them. Is that correct?
I believe there are potentially, you could think of something that does that, but.
I can't. So
Yeah, I
can
know, and I am kind of back to, I thought about equitable tolling, something else. But, and I will say, I think it's a little broad to say they well, you didn't say they automatically would have a different date. Or they automatically, are still allowed when they screw up limitations to go with the equitable subro. You didn't say that quite directly, but generally, equitable subrogation is for things where, unbeknownst to you, there was something wrong with your lien, and you've been given the right to use the other lien, which certainly gives you plenty of rights to encourage the refinancing industry.
Any other questions? Thank you, Ms. Pendry.
Thank you very much.
Mr. Sutton, I believe you have 5 minutes.
How do other states treat equitable subrogation and the accrual date for limitations purposes?
Your Honor, I think we indicated in our brief, if I'm not mistaken, that a number of other states do look to the maturity date of the original debt, but I'd have to.
There was a lot about what the federal district courts have done in the Fifth Circuit, but I wasn't
All right, well,
clear about
beyond what we have in our
general, if there is a prevailing general rule in other states.
If there is, I don't know it. Now, Justice Boyd, make no mistake. The answer to your question is an emphatic correct. They are ripping any meaning from Howard 2 with their position. There is no situation where if the accrual point is the maturity date of the refinance lien, there is no situation where equitable subrogation would give any value, despite this court having held just last year equitable subrogation is the reserve parachute in the context of a statute of limitations bar. Now, interestingly, the Howard said at the very end, well, maybe there'd be equitable tolling. And I want to note, the Howards just now made no response to the point that how in the world can a claim, the statute of limitations be running on a claim when you can't assert it? And they don't dispute it cannot possibly be asserted until the statute of limitations bars the refinance lien foreclosure claim.
But that's the same situation with quantum meruit, and yet we use the same accrual date for quantum meruit as if it was a breach of contract.
Well, but I think you can plead quantum meruit and breach of contract in the alternative.
And you can't plead equitable subrogation and an action on your note in the alternative?
I don't think you can plead, I don't think
we
you
see
can.
that quite a bit.
I don't think you can plead equitable subrogation until there's a time bar. It would be due to be dismissed because there is an adequate remedy at law.
Same with quantum meruit.
This court said in LaSalle, you cannot assert equitable subrogation until there's an adequate remedy at law. And so,
If there's an adequate remedy at law.
if there's an adequate, yes, sir. If,
So the flip side to my question to your opponent's counsel is, are there circumstances in which a refinancer is unable to foreclose on their lien, enforce their lien, for reasons other than limitations, in which circumstances the ability to foreclose on the original lien through equitable subrogation would still be valuable to the refinancer?
oh,
Right.
I think there are,
So really, the Court of Appeals ruling here basically says equitable subrogation under the circumstances of Howard 2 is really no value.
that's right.
Because limitations bars 2, it necessarily bars 1, but that doesn't mean equitable subrogation as a whole has no value to a refinancer.
That's correct, but
Okay.
I think what's going on here is the Fifth District Court of Appeals was overruled by this court when it said you can never resort to equitable subrogation to overcome a statute of limitations bar. And so then on remand, what the court had said you can't do through the front door, they tried to do through the back by adopting this notion of an accrual point that's the same accrual point as the other claim. So they're effectively overruling Howard 2. And I want to note...
Let me take you back to Justice Blacklock's question about the policy reasons behind the doctrine. If taking as a given what we've said, that the policy reason is to encourage refinancing and make credit more available, why would we continue to extend equitable subrogation in a case where that policy cuts both ways, given what the amicus has said?
Well, I think that the court has already covered that ground in Howard 2, and another primary policy reason that dates back to the First National Bank of Kerrville case in the 1880s is to avoid unjust enrichment to the defaulting debtor. And so that's another critically important thing.
Why wouldn't that rationale, though, apply equally to the original mortgage? I mean, under that rationale, it's just people should never get out from under their debt, and so we're going to give the lender rights it didn't bargain for to make sure it gets paid.
Well, but I think the issue is it's a defaulting borrower. It's not...
I mean, the original mortgage does not, if the original mortgage holder does not follow the rules, they don't get to foreclose. They don't have this parachute that the refinancer has. The refinancer has special rights. In either case, if the debtor's getting out from under the debt, if there can't be a foreclosure. So I mean, why wouldn't we apply the same rationale to the original debt?
May I respond?
Yes, you may.
Justice Blacklock, I disagree with the premise in that the original lien holder would be able to assert the lien.
But they fail for whatever reason. Statute of limitations or whatever reason they fail to do that. They have no parachute. Is that unjust enrichment that the court should be seeking to remedy?
Well, I mean, my position would be when you have people who've lived in a home for over a decade and not paid a dime in taxes or in mortgage payments, it's unjust enrichment. But I think the point is that, that really, I think, is water under the bridge after Howard 2, because this court said in Howard 2 you can resort to equitable subrogation, and they've not asked for Howard 2 to be overturned.
They have not, and we may need a case where somebody asked for that before we consider it. But it seems to me that if somebody came into court in the year 2022 and said, look, we have a contract with the other party, and we didn't follow the terms of it, but it'd be really unfair if you let them out and just enforced our contract as it's written, and so you need to give us some equitable rights to make sure that we're covered. I mean, you couldn't make that argument with a straight face in 2022 to this court about some other arrangement. And it's just interesting to me that whenever this arose, people approached it so differently, such that this was considered a situation that equity needed to intervene and remedy.
Mr. Chief Justice, may I conclude?
Yes. Yeah.
Look, I take your point, and I guess where I would finish is where I began, which is if you look at what the court said in LaSalle, that the equitable subrogation right does not derive from the refinance contract note or the refinance lien. You can't reconcile that with what the Dallas Court of Appeals did, and the Howards have never, in their brief or today, explained how you can. So we think the case should be reversed and remanded for proceedings to determine the amount owed. Thank you.
Any other questions? Thank you, Mr. Sutton. Case is submitted, and the court will take another brief recess. Please be seated. We'll hear argument in 21-1063, Henry Kappemeyer.
May it please the court, Mr. Sutton will present argument for the relators. Relators have reserved 5 minutes for rebuttal.
Thank you, Mr. Chief Justice, and may it please the court. The question before us today is, if a homeowner sues an entity which claims to represent all the homeowners in a subdivision, and the suit is about that association or that corporation's own actions, does the homeowner also have to sue all of the members or shareholders of that corporation or entity? In this case, it is somewhat surprising that a homeowners association, a claimed homeowners association, over 700 persons, when sued for something it did, then told its homeowners, in essence, we want them to sue all of you too for what we just did. What I will argue today is that this court's jurisprudence, beginning in 1977, makes the jurisprudence clear and coherent on this question. But what happened is when cases shifted into the homeowners association context, things became muddled. In essence, ignore Rule 39 at your peril. Rule 39 renders the jurisprudence coherent. And so I'd like to cover two areas today which generally track Rule 39. First, is there an entity which purports to represent the homeowners? I've given you as an exhibit permutations on this question, which is some subdivisions have no mandatory homeowners associations. Some do have a mandatory homeowners association, and some have a purely voluntary homeowners association. In all the cases, these are entities. And so this question about whether there's an entity goes to the question under Rule 39A1. Can there be complete relief among the parties or between the parties? And relatedly, will there be prejudice to a party if there is not joinder under the Declaratory Judgment Act? The second question, the second issue I'll cover today is, does anyone besides the entity claim an interest under Rule 39B2? And this is the point at which several of the cases after 1977 and also after 2004 in this court's decision in Simpson and Brooks against North Glen, they go astray and they get the answer wrong. And the essence of it is they forget to apply Rule 39. Okay, first, Rule 39's requirement of complete relief, the first of two alternatives for requiring joinder. So if someone brings a motion to abate pending joinder, they can either show the first prong, one that complete relief can't be afforded without a party, or if they can't show that, they can go to the second alternative, which is that joinder, I'm sorry, I'm losing track of this, that someone claims an interest in the subject matter of the litigation. Okay,
what do we do with the apparent inconsistency between the Declaratory Judgment Act rule for mandatory parties and then the Rule of Civil Procedure?
There is no inconsistency. This court said in the Clear Lake case, which is, I should give you the citation because we didn't have it in our briefs. This was a case that was relied on in 2004 in the Brooks case and the Simpson case. Clear Lake is 549 Southwest 2nd, 385. And so in 1977, this court said, these are essentially the same thing, and you must satisfy Rule 39 in a declaratory judgment case. And so the court said, in essence, these are kissing cousins. Both have to be satisfied in a declaratory judgment case. In the case we're talking about today, the Kappemeyers brought suit based on something only the HOA's board of directors did. The HOA board recorded a new set of restrictive covenants. And the Kappemeyers claim, very similar to the claim in the this court's Simpson case in 2004, said, in essence, these restrictions aren't valid, but they pled that more carefully than happened in Simpson. In Simpson, back in 2004, Simpson pled the restrictions need to be declared void, suggesting that everyone would be affected. I think the Kappemeyers took the lesson from some later cases that you probably ought to plead this more carefully.
So you think the pleading here is more like the one in Epernay?
The pleading is like the one in Epernay, and there are a number of those cases, like In re Corcoran, where the plaintiff was careful to plead relief solely for themselves. One of the cases involves a basketball court, but another of the cases does involve essentially voiding deed restrictions.
And if they don't agree that it's sufficiently narrow, presumably you would want an opportunity to replead.
That's right. And there were cases several years ago where I got this challenge, and I repleaded to make it more narrow, just to avoid any conflicts on this, because I don't need broader relief if I'm trying to protect my rights. And so the Kappemeyers pled, HOA, whatever these restrictive covenants mean, whether they're valid or not, you can't enforce them against me.
Did the Kappemeyers' restrictive covenants and conditions contain anything about amendment and how that could be done?
These restrictive covenants, my recollection is, don't have an amendment clause. And so the association is relying, they have a nullification clause. And so the association would be able, because there is an association in this case, it just doesn't happen to have authority over the Kappemeyers. The association is relying on Chapter 209 of the Property Code, which is a fairly new provision that says, if there is a mandatory association which has any kind of assessment or levy power, then the restrictive covenants can be amended by a 2/3 vote of the owner. And so that, I think, solved the issue here, whether there could be amendment.
But the Kappemeyers aren't relying on the interpretation of restrictions or covenants that apply equally to others in the Unit 1 of Key Allegro to invalidate the homeowners association's interpretation here. In other words, they're just saying we're not bound by it, but they're not relying on some other set of restrictions or covenants that might apply to to homeowners that are similarly situated to them.
Correct. They are relying solely on the restrictive covenants for Unit 1, which has about 200 homes. Now,
Has about what?
About 200 homes.
Right.
There are 5 sections, and all the restrictive covenants are identical. So for the 700 people, anyone who's been affected like this could bring the same kind of claim that they did, or alternatively could be subject to some kind of claim by the HOA for assessments. What the HOA did with the new restrictions is adopt a new set of identical restrictions for all 5 subdivisions, in essence replacing the ones that had been there for the 5 before. I think the key to understanding the first prong of this case is actually that Arnold versus Addison case from the Dallas Court of Appeals from 2021. This is such an interesting case because I think what it tells us is that we're dealing with a lawsuit against a nonprofit corporation where someone is saying, in essence, you have to pierce the corporate veil and go sue everyone who's a shareholder or a member because they're, quote, as the HOA says in this case, affected by it. Well, that would be as if Apple Computer were sued for a design defect with its phone, and a court said you have to sue every shareholder. It's no different, and that's what the Arnold case actually tells us. So you'll recall that in that case, the homeowner was making the same kind of challenge, actually, that the Kappemeyers are making. There was a problem in how a board adopted a new set of restrictions. And the homeowner also sued the 5 individual directors. And the court said, you can't get any relief against the individual directors because they were acting as a corporation when they did this. Well, by the same token, you can't get relief against the individual 700 owners in this case. They can't go on their own. No individual owner could go record some new set of restrictions which withdraws the prior set or changes it. Only the board that recorded this, what we assert is an improper and invalid set of restrictions, could go record something new which either corrects it or reflects a judgment by a court that says they're not valid.
That sounds to me like a very sensible rule for mandatory joinder, that you would look to whether, as between these two parties, there's a judgment that could order the one to do something that would provide relief to the plaintiff. But I wonder whether that's inconsistent with the rule of civil procedure. The rule of civil procedure seems broader. It seems that it would suck in people of whom that is not true. I mean, people who, as a practical matter, might have their rights impaired or impeded. There could be people in that category that would not be proper defendants in the sense in which we normally think of a defendant as amenable to some order or judgment that's going to redress the injury.
Justice Blacklock, I think that is the single most interesting issue in this case, and that's the reason that I provided the exhibit beforehand, and I want to talk about that now. There are 3 fact patterns mentioned there, and I want to talk about the first one, which is, what about a situation in a subdivision that has 700 people but no entity representing the homeowners? Now, I've had many cases like this, and I've had cases where we challenged a set of deed restrictions as completely invalid. Usually it's because they expired 10 years ago. Now, how do these cases arise? Typically they arise because one homeowner says to another, you can't build that, or you have to stop doing something because the restrictive covenants forbid it. And what we say is, well, no, the restrictive covenants expired 10 years ago, and we want to get the jump on you on attorney's fees. We have to be, for complicated reasons, we have to be first into court to preserve that claim. So we're going to file a DJ against you, Mrs. Smith, next door, who has said we can't do this. And we're going to ask the court to declare what? The deed restrictions expired. Well, we can say for sure that 700 people are affected if a set of restrictive covenants which expired 10 years ago are actually declared to be no longer in force. But that's not the way the case arose. The case arose under the kissing cousin of Rule 39, the DJ Act. There is a live dispute between 2 people, and I filed a suit to get that attorney fee claim, but the essence of the dispute is whether there's a breach of restrictive covenant. And if the court declares that the restrictive covenants expired, that is complete relief between those 2 parties. And under the DJ Act, no other homeowner is prejudiced in being not able to bring the same kind of suit. Now, I want to change up the fact pattern a little bit.
What if another homeowner claimed the interest? So in other words, you're challenging the trial court's requirement that you join all these additional people. But do you concede that if another homeowner decided my interests might be affected here, I want to intervene, would you oppose that? Or do you believe that there's permissive joinder at the very least here?
Permissive joinder, certainly, that person has to basically show jurisdiction under the DJ Act. Well, that person either has to claim a breach of restrictive covenant, which would confer jurisdiction, but under the DJ Act, you have to show there's a live controversy. So if they come into court just saying, oh, I wish the court would say this, but they don't actually have a dispute, there's no jurisdiction. But in HOA cases, as a practical matter, if someone says, I dispute your right to do this, there is a live controversy under the DJ Act. So then in 1977, this court says, well, then you still have to go through the exercise under Rule 39. We know there's jurisdiction, but is joinder mandatory? So there would be permissive joinder. But then, said this court in 1977, that's the Clear Lake case, you must analyze this under Rule 39. And I'll jump ahead, which is to your next point. This is that second prong of Rule 39A. The person seeking joinder, if someone is asking other people to be brought in, has to show, they have the burden to show, that that person does claim an interest. Now, that language is also in the DJ Act. So what you have in essence...
Except DJ Act says persons who have or claim. Is there a difference between those?
Yes, there is. I think the DJ Act is broader, and if someone has an interest, they must be joined, but under Rule 39, the burden of showing they must be joined falls on the party seeking joinder. And then under Brooks in 2004, they have to actually demonstrate that interest in order for those particular people to be brought in.
I mean, it seems to me here that the HOA could come to court and say, even if we just limit it to Section 1, or even more broad, all of these owners of canal lots have an interest in the outcome here because they're going to have to pay more if the plaintiffs win, right? And so they all have an interest in the outcome here. To me, that is hard to argue that doesn't satisfy the DJ Act's requirement. But it may be that none of those canal lot owners, have in any way expressed that interest or claimed that interest, and therefore you're not satisfying the rules.
39A1 isn't satisfied. Right. This court said you have
and
to
so
satisfy.
What result there? You're satisfying the DJ Act requirement, but you're not, that says you must join a person who has an interest.
You said in 1977, your predecessor said, well, you still have to satisfy Rule 39A1. You have to prove that they have an interest. They claim an interest.
So then if the HOA comes in here and says, look, there are, I don't remember the numbers, there are 37 canal lot owners here, and 7 of them have sent letters saying, we hereby legally demand that you do not agree with the Kappemeyer's demands here. Because if you do, you're going to negatively affect our interest. Now, have they claimed an interest, those 7?
I have never yet seen, and I don't think in any reported case, there is an HOA that has provided evidence that another homeowner claims an interest, and I don't exactly know what that evidence would be.
So a letter from a canal lot owner saying, we understand that these bay lot owners have demanded that you unamend the restrictions and take this away, and we are here to tell you that we have an interest in this, and we demand that you don't unamend the restrictions.
That satisfies Rule 39A1.
Don't you think that satisfies? There would then be 7 of the 37, or whatever the numbers are, that you would have to join.
Yep.
Okay.
Exactly. You come into court, I as a plaintiff do want a good adjudication of the claim. I don't want 7 other people in that HOA to come after me for breach of restrictive covenant, and the reason I don't is because if they sue me first for breach of restrictive covenant, even though I just got a judgment against the HOA, or if I didn't and these people win, they have a mandatory attorney fee claim, but I can't get my fees paid. That's why these DJ cases by homeowners come up. Because strategically we have to file first. But we only want relief for ourselves. Now, I suggested another alternative to the HOA or the subdivision that has no HOA. And again, let's say there are 700 people, usually it's less than that, for an older subdivision with just restrictive covenants. You know, you can't graze cows and you have to build a house of no more than 2,000 square feet. What if I'm just trying to sell my house and the person who buys it says, look, I'd like to buy it, but I'd give you more money if there were no restrictions so that I could, build a gas station. And so I go into court, and with no real controversy between anyone, I say, court, I want a declaration that these deed restrictions are not wholesale invalid. Well, first, who do I sue? No one has actually threatened me. All I have is a desire to sell my land. Probably at that point, there's no live controversy. But I do, in essence, want a clear title. And, we asserted clear title in this case. And there was never an issue whether we could seek relief just for ourselves for quiet title. We were told we'd be dismissed if we didn't join for our DJ claim. But nevertheless, I do have a real problem in that I need to close.
Your time has expired, Mr. Sutton.
Oh,
Any
I
other
was looking at
questions?
the wrong light.
We'll hear from the real parties.
May it please the court, Mr. Godkin will present argument for the real parties in interest.
Good late morning to all of you. It's a privilege and honor to be here. I want to apologize in advance if I have to sip the water. The live capital music of the world and the allergy capital of the world in Austin has affected me. I'd like to address why we're here. I disagree, with all due respect to Mr. Sutton. The question before the court is a very simple one. Did the trial court abuse her discretion in ordering joinder in this case? Meaning, did she just ignore the rules, the law? Did she fail to follow any of the principles, guiding principles set out by this court and other courts? The answer is a resounding no. Judge Bauer held a hearing. It was an evidentiary hearing where I presented the only witness. That witness was Ms. Lynn Powers, who is the board president. She testified without any contradictory evidence presented by plaintiff's counsel at the hearing that this would, in fact, impact all remaining owners in the community.
Why do we reach that issue under 39A2 if there's no one else claiming an interest?
I, with all due respect, Your Honor, disagree with the interpretation of how Mr. Sutton is presenting Texas Rule of Civil Procedure 39.
Well, it seems like we followed that interpretation in the Crawford case, where we said that if you don't have to join adjacent landowners in an oil and gas context, and it seems like the facts here are pretty similar, and so I'm wondering why this isn't a case where there's no joinder under Crawford.
Yes, sir. Crawford, I believe, is distinguishable in the fact that I believe under that scenario they were not parties to this contract. All of the owners in this community are subject to the restrictions made the basis of this lawsuit. I do believe that the issue of are the remaining owners going to be impacted?
It seems like in the Crawford case, there was actually more of a risk of inconsistent obligations because the other people who were being paid under the unit were actually got more royalties than the party to the case contended they were entitled to. So there would have been inconsistent obligations on the defendant. It might have had to pay twice, and we said that doesn't matter because none of the other people who had to be paid had come forward and claimed an interest.
Yes, Your Honor, but again, we're talking about in that particular case, the way I understand the facts of the case, was that we're talking about folks that were not actually part of that contract. In this case, all of the owners, the remaining 700 owners...
Well, they were all part of a unit agreement, I think. Isn't that a contract?
Yes, sir, it is, but they were also neighboring parties. In this case, what I think is critical is that this court has already decided, and referencing Dahl and the Brooks versus North Glen case, that this is, as well as going back 35 years to the Inwood HOA versus Harris case, these are fundamental property rights that are being affected by this declaratory judgment. And in fact, if you look at the Inwood case, the case law that is set out, or the language set out in the opinion of the Supreme Court, talks about the fact that the pro rata share of what is being paid for assessments and making sure that everyone is paying their pro rata share, that is a fundamental property right. The very issue in this particular case that Mr. Sutton's...
So is a payment on an oil and gas lease.
Yes, Your Honor, I understand. But Judge Bauer, in her discretion, looked at all of this. Judge Bauer looked at the evidence presented, the briefing, the arguments of counsel, and she determined on her discretion that the joinder was appropriate under the facts and circumstances of this particular case.
If there's zero evidence, and I know you disagree with this, but if there is zero evidence in the record that any person claims an interest relating to the subject of this action, then wouldn't the trial judge have abused her discretion by requiring joinder under A2?
I think if you were, it's a very good question, Your Honor. I think if you were to look at failed to look at the circumstances in the prior case law set out, including the case law and coming from the Supreme Court and the Inwood matter, that has already established these are fundamental property rights owned by the remaining owners.
But they haven't claimed them. That's his argument.
I understand.
So it's your position that claim means something different? The mere fact that they have them is sufficient? There's no doubt especially the canal lot owners, have an interest here, a valuable property interest, presumably. I mean, I'm not disagreeing with your position there. But did you have some burden to show that one or more of them claimed that interest?
I have not seen a single case cited that discusses in the HOA context that we would actually have to present evidence from other remaining owners that we believe we have an interest that is being claimed here when it's already been set out as a matter of law for 35 plus years by the Supreme Court that interest already exists. So really what would be asked of us as a homeowners association would essentially be this. We would have to go and essentially seek from the community do you claim an interest, yes or no? And if you claim yes, by the way, you're going to be brought into a lawsuit. From a practical standpoint, Your Honor, that would make it almost impossible to govern.
So that what you just focused on, that's a fundamental difference, isn't there? That a person petitioning an intervention, asserting that they have an interest and requesting mandatory joinder is different than a person who is sued and being directed to be hailed into court.
Correct.
Maybe with no intent of wanting to be there or any assertion of a claim. Could the fact that 39.2 talks about claiming an interest be addressing that difference?
That's a very good question, Your Honor, and I believe the answer is from again, when you look at the case law and what has already been determined as a fundamental property interest and the right of those to be protecting that interest to be brought into the lawsuit, I think it is different. I mean, one of the things that was addressed in the briefing is somehow the association's counsel, or association through its counsel, is representing all of the property owners. I don't represent Mr. and Mrs. Jones and their fundamental property interest. That is not my job as the association's counsel.
So if you were representing Apple Computer, you wouldn't be representing the interests of the shareholders?
If I were representing, I would think it would depend on honestly the context of the case.
Assume it's not a shareholder derivative case, that it's just, Apple Computer is suing somebody for failing to pay on a contract.
I'm representing Apple Computer, the entity.
Right.
I'm not representing
Nobody would come into court and say, well, I've got a fundamental property interest in Apple Computer because here's my share of stock. And whoever is suing Apple to collect on the contract, you've got to bring in all the shareholders.
I think that's a different situation because in that particular case, if I'm suing on a contract representing Apple Computer, I'm suing on behalf of Apple Computer. There is a fundamental benefit to the shareholders if I'm ultimately successful in recovering under that breach of contract lawsuit.
But the shareholders have an interest that may be impaired or impeded, so do we need to join them?
I think, no, sir.
You're not representing them.
I'm representing a company.
Right. But the shareholders have an interest that may be impaired or impeded, and that seems to be your position on all that's required.
I think what is unique and separate here is this. In the Apple Computer context, for example, I'm representing Apple Computer in a $100 million breach of contract lawsuit with a chip maker. Is there a benefit if I win to the shareholders? Absolutely. Are they detrimentally impacted if I don't win? Absolutely. But again, it is a fall down by being a shareholder. This is a different situation. 35 years, this court has said, these are fundamental property rights that are being impacted when someone seeks a declaratory judgment, seeking a declaration that the governing rules no longer apply. This impacts everything. You've got to remember, Your Honor, where this comes from. These were from 1960. There was
before
racially.
that, they're from the federal rules, which have a parallel provision in Rule 19. And so I started doing some looking about what do the federal courts do with this, and you may have looked at that as well. But it does seem that federal courts note that you can frame declarations to avoid joinder problems in general, and then more specifically, the Fifth Circuit has held a couple of times that if you've got co-tenants in the same interest in land, and you're only seeking to adjudicate your own interest, the other co-tenants need not be joined. So that's a fundamental property interest, but why is that wrong?
I think under, well, could you clarify your question on that when you say why is that wrong? What specifically are you?
Well, the Fifth Circuit says you don't have to join your co-tenants if you're suing to establish what your interest in the land is.
Mm-hmm. Well, because in that particular case, I would assume that you have a co-tenant that is representing your interest. It's a co-tenant. In this case, again, Mr. and Mrs. Jones, they're not part of this. They're not, their fundamental property interest is not being represented.
In those cases, they were only seeking to adjudicate their own interest and had framed the decree narrowly to avoid adjudicating the interest of the co-tenants. But it seems like that's inconsistent with the idea that once there's a fundamental property interest, you got to join everybody.
Well, Your Honor, I think, again, when Judge Bauer looked at the evidence in the case and the briefing and the arguments of counsel, and her discretion felt that this was appropriate ruling, and joinder is seldom overturned. I think every judge, when faced with situation, is going to look at each particular situation.
You don't think it necessarily would have been an abuse of discretion if she had gone the other way?
I would have been disappointed. Would I have thought it was abuse of discretion? Probably not, no.
So if you know, your friend on the other side, instead of wanting to get a jump for attorney's fees, waited for you to enforce, and then as a defense to the enforcement says,
yes,
no, the governing documents are invalid, they have no claim over me, et cetera, would they have had to try to get 700 people in, or we just say, well, no, that's a different procedure?
That is a very, very, very good question. And it brings up the second part of Texas Rules of Procedure 39A2II. It, by not allowing for joinder, it opens up the association to a multiplicity of suits. And that was addressed specifically in Brooks versus North Glen by the Texas Supreme Court. In that particular case, a homeowners association did not seek an abatement. And the court said, we appreciate the risk that unless each homeowner is joined in one suit, North Glen may be subject to inconsistent judgments. And, but it failed to bring up the abatement at the trial court level.
But I'm saying if you started the suit instead of
right.
Kappemeyer.
And under that circumstance, our firm represents a litany of homeowner associations. That's exactly what I would expect. Every time a homeowners association would go to an enforcement action, what you're going to get back is a counterclaim saying, but the governing, the declarations were passed improperly or what have you. And so that's what you're going to get. From a policy standpoint, it will actually encourage exactly what Texas Rule of Civil Procedure 39 says needs to be discouraged.
And so in that situation, when that happens and there's a defense that's a counterclaim that says the declarations are invalid, are you typically successful in getting those dismissed if they don't join all of the other homeowners?
I will tell you, that's a very good question as well. I will tell you, having done this a very long time, what we call the Dahl motion is rarely used. It is something that and again, respectfully disagreeing with the position set out in the briefing by Mr. Sutton, it is not something that is typically used as a sword. It is a very unique circumstance, like in this particular case. But
your position is it could be successful.
It could be, absolutely.
In every case.
And as in certain circumstances, it probably would. I mean, what you have here, and what you typically have, is a rogue owner, here one of 700, that waited 3 years to file a lawsuit after the amendment. And in doing so, it's going to negatively impact the overall community if he is in fact successful.
Well,
Just-
that's the part I'm missing, because it's not going to bind, the judgment in this case won't bind Mr. and Mrs. Jones.
Right, because of the res
So it's only
judicata
going to
issue,
adversely
yes.
affect you.
Right, so
Because
this
you
is,
might have to pay the Kapmeyers, or take the responsibility yourself, or enforce it differently, however it comes out. And the question is not whether you can join them. Surely you could join them all if you wanted to. The question is whether they have to join them.
right.
And why should they have to if you don't want to, and the judgment is not going to bind any of them?
For the Texas Rule of Civil Procedure, irrespective of getting into the issue of do we have to prove that people want to be joined, Texas Rule of Civil Procedure 39A2II says it opens up an existing party, here the homeowners association, to the potential for inconsistent, a multiplicity of suits and inconsistent judgments.
Consistent obligations by reason of his claimed interest. Right, so the threat of inconsistent obligations has to arise from the claimed interest. So we're back with there being no claimed interest by the prospective targets of the joiner.
Right. In Brooks, again, Brooks versus Northland addressed this very issue. And it talked about how the Supreme Court on its own said this. We appreciate the risk of multiple and inconsistent judgments. We have some homeowner associations we represent that actually are in two different counties. I mean, and of those two counties, you have a litany of judges. However, a fact finder finds in one court, in one county, may be consistently different than what's done in another. How would one expect a homeowners association to govern under that circumstance? You're going to have islands where this particular property had a ruling in their favor, and they're not subject to the governing documents that they signed up for when they moved into the community because of what I truly believe would be a bad ruling. How is that, again, affecting the fundamental property interests of the others? When you look at Inwood, that says one of the things is a fundamental property right of all owners in a homeowners association is to make sure that people are paying their pro rata share. If Mr. Kappemeyer is successful in his lawsuit, someone will be paying his assessments.
I don't understand that, because if I were that someone, I would say, you lost the lawsuit, you pay it.
If Mr. Kappemeyer is successful in his case, is what I'm saying.
No, I'm saying that the next homeowner down the street wouldn't say, oh, well, you lost your lawsuit, so I have to pay part of his share.
Well, that kind of brings up the issue exactly. And that exact scenario could happen. I'm not paying because a declaration was made by a court that says that the governing documents were invalid as they were ultimately put into place. Okay, under that circumstances, just like you said, Your Honor, I'm not going to pay. I'm not going to pay. I'm not going to pay. So what does a homeowner association do in that regard? That's exactly why they have to be part of the suit. You're going to have multiplicity of lawsuits.
Back that up, and so, all right, let's assume we agree with you and we affirm the Court of Appeals here. The Kappemeyer say, well, we don't want to sue all our neighbors, so we're just going to non-suit, but we're not paying. We're not paying the extra portion that the HOA wants us to pay. So now the HOA has to decide, now what do we do? Let's enforce it. So you sue the Kappemeyers.
Right.
Why doesn't Rule 39 require you to sue all 700 homeowners, or at least all the other Bay Lot owners?
Because I would not be seeking a declaratory judgment. I would be seeking a breach of contract based on their breach of not paying under the governing documents, which is construed as a contract.
Okay, and so then in response to that breach of contract claim, they file a counterclaim for declaratory judgment that we don't have to pay it.
We're right back to where we are right now.
You say now they would have to sue all 700.
We're right back. I don't, but that's what I believe the Declaratory Judgment Act says. Yes, I do.
I mean, is this a situation where you might actually prefer an action brought under Rule 42 so that you would not be subject to inconsistent obligations?
Help me understand your...
a class action. I mean, would you be complaining if the other side had managed to find some people, a canal owner, or a bay owner, a handful of people from each of the units and asserted this as a class action?
It's a really interesting question that I went over with my partner yesterday in preparing for this argument. And the problem in that circumstance is when you get into class action and class status, it opens up such a litany of complexity that, frankly, I think is unnecessary because it's already addressed in the Declaratory Judgment Act. Please keep in mind, we're talking about homeowners associations that are governed by people that are volunteers serving their community. I know oftentimes we look at them like, for example, the Apple computer example brought up here today. It's not. This is simply a $300 a year assessment so roads can be fixed and maintained, parks can be maintained, and a pool can be maintained. And when you start talking about class action status, then you're really talking about, it's just frankly prohibitive when you're with a volunteer community association.
Isn't it prohibitive to have to sue 700 people for a $400 assessment too?
With all due respect, when you have what is typically what we see, 1 out of 700 deciding that they don't want to follow the rules, no. Your Honor, with all due respect.
What was one of 7,000? There's a homeowners association in Florida that has 7,000 owners and 20,000 homeowners.
And I think under that circumstance, I think the court would have to consider that in the discretion that is given to them by the rule.
But what about the fundamental rights of property?
Again, it is up to each particular judge and each particular case.
Each judge can just, fritter away somebody's fundamental right to property interests.
Under that circumstance, I would have to know the facts, but if it was an outright, we don't want the governing documents to apply to the other 6,999, the answer would be yes.
That they could. So it's okay to fritter away somebody's fundamental rights to property if there's a lot of people whose rights are about
no, I said they should have to be brought in. Yeah,
okay, so 700, maybe it's
I think
it's like a winning and losing.
It is a circumstance, particularly each case. In my personal opinion, if you're asking me, if you're going to seek a declaratory judgment that's going to impact the other 6,999, they should be brought in. Yes.
So what I've heard you say, I think, is that the key right that's at issue is to not have to pay the other people's share.
Well, that is a fundamental property right as set out by this very court.
Who would be better to represent that interest than the property owner association itself?
I'm sorry.
Who would be better situated to represent that? Why would each individual property owner be better situated to defend the right not to have to pay the Kappemeyer's interest than the homeowners association that in theory exists for that exact reason, to make sure everybody's paying their
Because that is a right not owned by the homeowners association.
What is the homeowners association for exactly then, if not to represent that?
The homeowners association is there to govern. It's a nonprofit entity formed under the state of Texas that is there to essentially govern using the governing documents set out when someone moves into the community.
And is representing all of these 700 owners, the board of directors, et cetera, is representing their interest by passing these laws.
Well, I think we're back to almost to the Apple situation. Yeah, is there a benefit when the homeowners association is an entity acting through its board, does certain things for the benefit of the community? Absolutely, that's its job. But it doesn't own the fundamental property rights of the owners.
And aren't we back to the Crawford situation too, where we said even if the person you're suing ends up having to come out of pocket twice for the royalties, which is certainly inconsistent, that's not enough if you don't claim, if there's nobody that's claiming an adverse interest. It seems like it's much worse for in that situation, the inconsistent obligations are even more glaring, and yet we said no joinder.
I think, again, Your Honor, with all due respect, I think it's a different, unique circumstance, and I just ask the court to look at the precedent that both trial judges, as well as, with all due respect, homeowners associations has followed, like in this case, as set forth in the Brooks versus North Glen matter. File an abatement and get the joinder. If the court uses its discretion and finds it's appropriate, they're brought in. If not, then we go about our way. I see that I'm out of time.
Any other questions?
Thank you all.
Thank you,
Again,
Mr.
it's been a
Duncan.
sincere pleasure.
Mr. Sutton, I believe you have 5 minutes.
Thank you. I'll address a couple points here in rebuttal. It will be remembered that the president of this HOA at the hearing, when asked what the HOA does, she said, well, we're the representatives of all the homeowners. And when asked whether the HOA had any evidence that anyone claimed an interest, she said no. Mr. Godkin is correct. These are all volunteers, and they're actually in a case which this court denied review for a client of mine recently, the Myers versus Tahitian Village. There are 7,000 lots in Tahitian Village, and we brought that as a class action. And the reason we brought it as a class action is because of cases, some from this court, that say the class action is the ideal way to deal with widespread abuse in a subdivision by a homeowners association. Here's the thing. Filing a class action is not a mandatory thing. That's a choice that a plaintiff makes. And that is a momentous choice because it's an expensive and difficult road. That homeowner was not forced to file a class action, but it is a good vehicle if it's the right case and the right plaintiff.
Would it be here when the interests of the different owners of the property all seem potentially conflicting? How would a class, would you have to have a small class of just people who are canal owner or non-canal, I can't remember which one it is, but anyway, people who are a small set of the 700 essentially fighting all the others? Is that how it would work?
Yeah, it's a real problem in this case because, well, we don't actually know among the 700 people, you know, who would have what views on things. The canal owners certainly have a different set of interests than the non-canal owners. So you might have to have some sort of a subclass. In Tahitian Village, we felt like we had everybody except the board on our side, so 6,993 people. In this case, I have no idea, and we would need class discovery really to understand more about what that class would be before we went into that motion for certification. That would be a difficult road in this case and expensive. The court was interested in this issue about whether someone's a plaintiff or the alignment of the parties, in essence. And one of the cases that gets talked about in this case is the Epernay case, which is extremely similar on the facts to this case. But in Epernay, one of the problems that the court identified, and that went our way, the homeowner did what we did, which is there were kind of broad claims about something being invalid, but the relief was only sought for the homeowner. The court said, the court did the Rule 39 analysis, but it also pointed out that the HOA itself had filed a counterclaim and yet did not join anyone. And I don't remember in that case exactly what the claim was and whether it would be something that would, quote, affect all the other homeowners. But it is another example where you have this procedural back and forth. As soon as a homeowner, whether it's a defense or a counterclaim, asserts something that could arguably affect everyone, or even if an HOA makes such a claim, under my opponent's rule, everybody in that subdivision has to be sued. And that's neither fair nor workable and constitutes a huge penalty in many cases. I want to say, elaborate or correct on something in our briefs. There are a number of cases that my opponent cites that we differentiate on the facts, like Dolly and Hartman. Also, there's a case out of Houston called Riddick against Quail Harbor, where it was a question of where the homeowner would win money because the homeowner's condo unit was damaged. And the court said, well, everybody's affected by that because all the owners would have to pay for it. April Sound Management is another case. The problem in all of these cases is that those are the HOA cases occurring after the 1977 Clear Lake case, in which the court seems to think an HOA is something different than a corporation and does no Rule 39 analysis. And that's the problem with all their authorities. There's no Rule 39 analysis. I thank you for your time. If there are no more questions, I will say.
Any other questions? Thank you, Mr. Sutton. Case is submitted. That concludes the arguments, and the case is set for this morning, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.